Senator Fawcett.
Thank you, Mr Deputy President. I too rise to address this bill, and I'd like to just comment on three aspects of the topic at hand. The first is around the actual issue of same-sex marriage, which is obviously at the core of what the Greens are hoping to achieve through this. The second is around the issue at hand that Senator Sims spoke to about, which is recognition and particularly the human rights of same-sex couples, and he referred to the case in South Australia, which I'll come back to a bit later, and that in itself is an issue that we do need to cover. But thirdly, just from a technical perspective, some issues with the bill, particularly going back to the Legal and Constitutional Affairs Legislation Committee that looked at this bill in 2014 and some of the conclusions that they came to. To come to the first issue, it will be no surprise to people who have heard me speak in this place before, and indeed in my former role as a member of the other place, that I don't support same-sex marriage. I make that statement quite openly, and I think it's important that as a nation, as we have this debate, there's recognition on both sides of the debate that people of goodwill can hold differing views on this topic, and that we should be able to have the discussion without name-calling, without putting people down, without labelling them. And so through you, Mr Deputy President, I would ask Senator Sims to consider the fact that the group he calls right-wing lunatics and a fringe group, that there are many people in mainstream Australia of good character, of goodwill, who share the views of people who support marriage between a man and a woman. And if we're going to have a respectful debate in this country, then that has to flow both ways. I'm sure Senator Sims wouldn't appreciate people who hold the same views that I do, calling him or others who support same-sex marriage lunatics or fringe groups or other things. Well, I would ask that that same courtesy is extended so that both sides of the debate can put forward their perspective, their point of view, in some cases their beliefs on this topic, so that as a nation we can have an adult and a mature discussion reaching a point in what is a very successful, liberal, plural, secular democracy. And that plural part means that there are people with different views, and their views have to be respected, and they have to be given the right to put forward those views without fear of the name-calling, or indeed, as we're seeing in Tasmania, being hauled before tribunals for putting forward their point of view. On the second issue, the very sad situation of David Bulmer-Rizzi was raised by Senator Sims, and I share his concern for the very human trauma and cost that situation revealed here in Australia. But like many things, we need to look at what was the root cause of the issue and the pain that was caused, other obviously than the tragic accident and the death of David. What was the thing that caused Marco the pain? In that case, it was the fact that he was not able to act as the next of kin, to make appropriate decisions about care, about decisions we made in the medical sense, or indeed actions after the death of David. This bill, I don't believe, directly addresses the root cause of that problem. As Senator Sims correctly identified, on the East Coast, state legislation has made it possible for somebody in Marco's situation to have made those decisions. And so the remedy for the kind of problems that he faced, being able to make those decisions, is actually found in state legislation. Now, Senator Sims is right that South Australia lags behind in that regard in a number of areas. We have seen bills come through that attempt to find a way forward in this sometimes quite complex situation of domestic relationships. And in fact, in 2006, the Domestic Partners Bill was introduced into South Australia, which recognises that in addition to married couples there are de facto relationships, and in some cases there are relationships that go beyond just an interdependent relationship, but two people who may not be the classic definition of partners, particularly in a sexual sense, but in a relational sense, can have the need for the same kinds of supports, provisions and legal rights as other people. And so we see in state law attempts being made in South Australia to bring forward legislation that increasingly recognise and get rid of discrimination for various kinds of relationships. And we also see in federal law changes that go to the issue of relationships. So whether we're talking about things like Centrelink or indeed the Family Court of Australia and family law, we see that in law the federal government has already taken steps to remove discrimination for same-sex couples. And so from March 2009, for example, in the federal family court, parties who are in an eligible de facto relationship can apply to the family court, for example, if that relationship has broken down. And before the court can determine that, you need to make sure that that relationship meets 4 criteria. And one of those is that the relationship was registered under a prescribed law of a state or territory. Now, South Australia is one of the places where they haven't currently got the ability to register, but they can register the relationship through a domestic partnership agreement. So the point I'm bringing out here is that this has been presented as a discrimination against same-sex couples. But if a heterosexual couple who haven't registered their de facto relationship wanted the remedies available through the federal court, they wouldn't actually meet the same, they wouldn't be eligible for that if they hadn't met those 4 criteria, which includes registering the relationship. And that is dependent in part on a state law. And so what we see is that the remedy to the situation that was highlighted with David Bulmer-Rizzi and his partner Marco is that state law actually provides the ability to recognise the relationship and to enable those state authorities to engage, in this case it would have been with Marco, so that he could have made the appropriate decisions as a recognised next of kin. And so I think it's important as legislators that if we identify what is seen as an injustice in our community, that the remedy that is put forward is by the appropriate level of government in Australia, so that the laws address the issue rather than creating broader concern or change within Australia's legislative environment. And that's where I come to the third part, looking at the specific issues with this bill. Australia is a sovereign nation. We have our own laws, and whether or not you agree with the laws, whether or not you support changes to the laws, they are the laws of Australia. They are the laws that all of us, regardless of our status, our position, are required to follow. And currently, Australian law is clear that marriage is between a man and a woman. It doesn't recognise other arrangements as valid marriages, regardless of whether they are celebrated in Australia or overseas. Similarly, the law doesn't recognise marriages of people from overseas who are already in a valid marriage, where they were entered into without consent of both partners, or, for example, marriages involving underage individuals. And so there are a number of aspects of marriages which may be quite valid overseas, which may not be recognised here in Australia. And if we start making changes against our sovereign law in the interest of one group, then why not the other groups? We have, as I said, 3 clear areas there in our law. For example, underage individuals. And if you look, I think Senator Sims mentioned some 14 countries overseas who support same-sex marriage. Well, there are many, many more countries who allow underage marriage and child marriage. And so if we see populations within Australia coming from those countries who wish to have those marriages recognised, if we're going to be consistent and we give up our sovereign laws, then we need to start recognising things like child marriage, which clearly I think Australians would reject and say that is not consistent with our values. So as a principle, allowing overseas law to override Australian law I don't believe is a good principle for us to be adopting. No matter how much you passionately value the cause, in this case it's same-sex marriage, once you give up that principle of maintaining our sovereign laws and surrendering it to the values of others, then there are areas that I think would be quite damaging for Australian society. As Mr Marco Bulmarizzi indicated himself, Australia has its own process to go through with respect to same-sex marriage. And I think he's, in that statement, recognising that we have a sovereignty here, we have a requirement that if we want to change that aspect of our law, then the process through the Parliament, through a plebiscite, through engaging the community is the way we've chosen to do that. And that will result in a decision one way or the other, but that will be a sovereign decision as opposed to surrendering our laws to those from overseas. So if the Australian Parliament were to remove the requirement that only a man and woman can be validly married in Australia, then the amendments would also be necessary to recognise foreign same-sex marriages. So clearly the government doesn't support that. So the history of this bill, it was introduced in 2013 and it didn't proceed. In fact, the second reading was negatived on the 20th of June 2013. That was the previous version of the bill. So Senator Sims has raised the point about people exercising their judgment and respecting the decisions of Australian people or the Parliament. And so I'd just encourage him to consider that in the history of this topic, there have actually been a number of times when bills have come before the Parliament and have not been supported. And so if he believes that people should be just following polls or following the decisions of previous votes in the Parliament, he should perhaps consider the fact that the Parliament has voted on these issues before and has not supported them. If he wishes to continue his advocacy, he needs to accept the fact that those who don't agree with him will likewise continue their advocacy against the bill. The Senate Legal and Constitutional Affairs Legislation Committee tabled a report on the 25th of September 2014 on this bill, highlighting a number of concerns which had been raised by various submitters, including the Attorney General's Department. Some of the issues that arise with the bill is that there will be potential for different treatment or a differential in treatment for same-sex marriages solemnised overseas, in contrast to same-sex partnerships which are recognised by some states and territories here in Australia. Likewise, same-sex marriages which can be conducted in foreign consulates in Australia and in overseas countries where same-sex marriage is not legal would not be recognised as valid marriages in Australia. There may be issues, and that would create what's already a complex situation in terms of the types of relationships, who recognises and what the impact is in law. That would make it even more complex. There may be issues in how the amendments of the bill would apply to same-sex marriages that have already been solemnised overseas, and it would need to be amended to ensure that the other current limitations on the recognition of foreign marriages in Section 88D, and that is going to issues such as minimum age, prohibited relationships and consent, are preserved in relation to foreign same-sex marriages. So the passage of the bill would by its nature create some considerable inconsistency with the current definition of marriage. It would mean that a same-sex couple could not get married in Australia based on the current definition of marriage under the Act. However, they could get married overseas and have the marriage legally recognised in Australia under the amended Section 88EA. And again, when it comes to sovereignty, if as a nation we have said we don't support same-sex marriage, and at the moment that's the status quo, that is the law, and until it's amended that remains the law, why should we vote to put in place a complex system where Australians can bypass that law by going overseas, and then us instead recognising the validity of somebody else's law to bring that relationship back. If the Australian people want that change, well then they will support a change to the law here in Australia. We shouldn't be giving up that sovereign aspect of our lawmaking by instead just accepting the laws from another country. It would indeed be seen as a means to circumvent or to create a loophole in Australian laws, encouraging same-sex couples to travel overseas rather than being married here. So, Mr Acting Deputy President, in conclusion, I clearly won't be supporting the motion. As I said, there are three elements to my position. One is the issue of same-sex marriage, which I'm on the record as not supporting. I just reiterate that Australians of goodwill and good character hold opposing positions on this, and neither side should be shouted down or prevented from putting forward their point of view in a respectful manner. Secondly, the issue that has led to Senator Sims and others very passionately advocating their position on this goes to the tragedy that occurred in South Australia several weeks ago. But as I made the point, the remedy to that is in fact found in state legislation, not in federal legislation. And to remove that injustice, then the South Australian government needs to bring forward legislation to mirror what is allowed in the East Coast, where somebody in that situation can make those decisions on behalf of a critically ill person. And thirdly, the issues with the bill itself, and as highlighted by the Senate Legal and Constitutional Affairs Legislation Committee, which in 2014 considered this bill and recommended that it not be passed. There are issues, complications with the bill that I think mean that it would not be wise for the Parliament to pass it, and as stated, I will not be supporting the bill.